This is one of the most important questions that I'm asked when parents come to see me, whether that's because their marriage has come to an end or that they're separating because they weren't married but the relationship's come to an end and they've got children together. And the most important thing is to look at what's going to be best for the children following that separation. And it's inevitably, or usually, the case that the children will need to live in two separate homes with their mother for some of the time and their father for some of the time. That's just how it often is. And so I always say to somebody, well, what would suit your children? And it will depend really on their age, their understanding, where they go to school, where they're living, what the proposals are going forward. Are they going to live near each other so that they can share time quite equally between each other, or are they going to be living further away, which would then mean that it would be better to have more time with one parent than the other during the week perhaps, but then in school holidays that might change. There's all sorts of options and arrangements that can be put in place, always with the children's needs and wishes at the forefront. Court is a scary word, and people are really quite afraid that if they separate, will they end up in a big entangled court process regarding their children? And the simple answer is that most cases don't end up in court. Most cases are resolved by the parents discussing arrangements between themselves and coming to an arrangement. And they might put that in writing, they might just have that through emails or, discussions, but they basically don't really need to get legal advice, unless they can't reach an agreement regarding the children, which is so important. And sometimes they find that it's helpful to discuss it with a third party. That might be a mediator, that might be a member of their family. And they sometimes may come to solicitors for advice, and that may involve some correspondence between solicitors to help them reach an agreement, and we can draw up a parenting plan and such like, setting out the arrangements for the children. But court is a last resort, and as a last resort, if they really can't come to an arrangement that they believe will be in the best interest of those children, then the court application is made, and the court then will intervene to assist in either helping the parties to make an agreement by consent, or ultimately the court will have the power to make an order of the children, taking into account their needs and best interests. And they will do that by looking at the Children Act 1989 and the welfare principles, and looking at what's in the best interest of the children based on a set of guidelines and factors. And all of that's taken into account in determining whether there's an order made by a judge ultimately that is imposed on the family for the children, or whether it's an agreement that's reached as part of a court process, and it's agreement by consent that the court can then approve, and that can become an order of the court over those children. But no, most cases don't end up in court. Most cases can be resolved amicably, hopefully, between the parents. This is a question that often comes up, and people often are of the understanding that if they separate, the children will live with them 50% of the time, with the other parent 50% of the time. And sometimes, arrangements are such that can happen, and the parties might live near each other, and that might work very well. But that is not always the case, and that's not something enshrined in law. It's very much a matter of what's in the best interest of these particular children. And it may not always be best for them to live 50% with one parent and 50% with the other parent. Sometimes it would be better for them, certainly depending on where the parents live, and certainly if they don't live very near each other, for them to live more of the time with one parent during the term time, for example, perhaps more of the time with another parent during school holidays, for example. Or it may be that they are with one parent more of the time, but every, for example, Wednesday night they spend with the other parent, and they split the weekends, so they'll have, one weekend with one and one weekend with the other. But then they might sort of then do a different arrangement over the school holidays, and that might be shared more in favour of one parent who the children have not been with so much during term time. There's all sorts of options and arrangements that's going to suit those individual children. There's no rule. It's all about what would be best for them. And that's really important, because not 50-50 is not best for all children. There are various resources available, for parents. There's Resolution, have got literature on their website, and so have CAFCAS, which is the court advisory service to the court, who advise the court and judges alongside the court process in terms of safeguarding and what would be in the best interest of the children. And so the CAFCAS website often has very good information and literature. The other resource that I think is very helpful for parents is a family law app. There are various ones on the market, and the beauty of a family law app is that all of the arrangements that the parties have agreed can actually be set out very neatly on the app, and often some of them have tone monitors, so it can assist in terms of the dialogue between the parents. It also can schedule medical appointments, school meetings, reports, etc. So it's all in one place, and I think it really helps the parties to have a cordial relationship going forward, that of course is then much better for the children. Financial arrangements are one of the most important questions that people ask me when their marriage has come to an end, or their civil partnership has come to an end, because obviously they're concerned about money. They're concerned about what's going to happen in the interim, what's going to happen in the longer term, what's going to happen in the future, what are their rights. And they do have rights, and those rights are set out in law. Those rights are set out in the Matrimonial Causes Act 1973. And so the financial claims that they have against the other party, relate to pension, relate to property, relate to capital, so, anything else really, other stocks and shares and savings, etc. And the starting point for division of assets that have been accumulated during the marriage is generally 50-50. Maintenance is separate, that's dealt with under income claims, and whether there will be maintenance paid to a spouse will be determinative on need, and whether there is a need for that to be paid. That's not just an automatic sharing, as the capital awards are. But then we look at, well, how do we arrive at, is it just a straightforward 50-50 case? And a lot of people obviously want to know that. And although that's a starting point, the court, or we as lawyers, will look at certain factors within the Matrimonial Causes Act under Section 25. And the most important factor will be the housing needs of any children. So if there are children involved, for example, it may be that a 50-50 split isn't a fair and justifiable outcome. And it may be that, therefore, there needs to be a departure from equality and the assets need to be shared unevenly. It will just really depend on the circumstances of the case, and indeed what the assets are, and whether the needs of the parties can be met from the assets without penetrating the other party's share, or looking at assets that have been brought to the marriage, pre-marital assets, or assets post-separation that would be treated differently by the court. So I think, what we always look at is, well, what's the position now? Because parties may be, looking to move out of the family home, for example, so they might need financial support with that, or they may need to live together for an interim period, pending an overall settlement when perhaps one moves out or the house is sold or something like that. So it's very much going to be dependent on the circumstance of the individual client, and what's going to be best for them. The other thing to say is that the financial claims don't just happen, they have to be activated. And those financial claims are activated within the divorce application, what used to be called divorce petition. And the divorce petition or the application to dissolve a civil partnership. And so the financial claims are set out within that document, and that opens those financial claims up. And once they've been opened up, they need to be closed down by way of an order of the court. And that order can be by way of consent, by an agreement that the judge is then invited on paper to approve and seal, or through a court process and ultimately a judge's decision. There are various different types of ways in which parties can work together to come to an arrangement regarding the finances ancillary to their divorce. It doesn't have to be through a court process. It can often be through correspondence with solicitors. It can be through mediation, where they will appoint, often a lawyer, a family lawyer, trained mediator, to facilitate discussions between the two of them, which will ultimately result in them reaching an agreement that then can be enshrined into a consent order and sent to the court. So mediation can be very effective. There's also hybrid mediation, where their lawyers are also involved, with them, with the mediator. It has to be the right type of case for that to work, but that's another option. Another option is arbitration, where, and there's different formats for arbitration. I can't go through them all, but again, it's another effective way of reaching an agreement. The other way is collaborative law. We have collaborative law trained lawyers at Blanchards who understand and can work with the collaborative process, where parties elect to not have a court process and have four-way meetings instead of correspondence, to sort of actually have discussions to reach an agreement. And again, that can be quite effective. And another way that I am finding more and more helpful are private hearings, where the parties actually have their legal teams together, but they will also appoint a private judge who will hear both sides of the argument, and then will give an indication as to what he or she thinks should happen in that particular case and how it should be resolved.